Your dual citizenship status that you've held for years without any issues could suddenly be under scrutiny in January 2026 because of new regulations that most people know absolutely nothing about. For millions of dual citizens in the United States and Americans holding citizenship in other countries, the law changes coming next month could affect your passport validity, your ability to travel internationally, your tax obligations, and in some extreme cases, even your citizenship status itself. If you're a dual citizen or planning to become one, what I'm about to share could save you from serious legal complications that are already catching people completely off guard. Welcome to U.S. Visa Information, your essential resource for understanding American immigration law, citizenship regulations, and visa requirements. I'm here to break down the critical dual citizenship law updates taking effect in January 2026, explain exactly who is affected, reveal what new documentation and reporting requirements you need to comply with, and show you overview of the January 2026 law, the steps you must take right now to protect your status. Whether you hold American citizenship along with another country's passport, or you're a foreign national with dual citizenship applying for U.S. immigration benefits, these changes will impact you directly. So, let's get straight into what's changing, why it matters, and how you can ensure you remain in full compliance. The January 2026 dual citizenship law updates represent the most significant changes to how the United States government tracks, monitors, and regulates dual citizenship since the major reforms of the early 2000s. These changes are being implemented through a combination of State Department policy revisions, Department of Homeland Security regulatory updates, and new enforcement protocols from U.S. Customs and Border Protection. The driving force behind these updates is enhanced national security concerns, improved information sharing between countries, and the government's desire to close what they view as loopholes that allow people to avoid tax obligations or circumvent travel restrictions by strategically using multiple passports. For dual citizens, this means increased scrutiny, more paperwork, and potentially significant consequences for non-compliance with requirements that many people don't even know exist. The first major change taking effect in January 2026 involves passport application and renewal procedures for U.S. citizens who also hold citizenship in another country. Currently, when you apply for or renew a U.S. passport, you're asked whether you hold citizenship in any other country. But enforcement of this disclosure has been inconsistent, and there have been minimal consequences for people who fail to report their other citizenships. Starting in January 2026, the State Department is implementing a mandatory dual citizenship disclosure system that cross-references your passport application against databases from countries with which the U.S. has information sharing agreements. This who is affected by the new rules includes virtually all European Union countries, Canada, Mexico, Australia, New Zealand, Japan, South Korea, and dozens of other nations. If the system detects that you hold citizenship in another country, but you didn't disclose it on your U.S. passport application, your application will be flagged for additional review, which can delay processing by several months. More seriously, if you actively concealed your dual citizenship by answering no to the question when you knew you held another passport, you could be accused of making false statements on a federal document, which is a serious offense that can result in passport denial, revocation of existing passports, and, in extreme cases, criminal prosecution. The rationale behind this enhanced disclosure requirement is multifaceted. First, the U.S. government wants to know if American citizens are traveling on foreign passports to countries that have restricted or complicated relationships with the United States. For example, if you're a U.S. citizen who also holds Iranian, Syrian, or North Korean citizenship, and you've been traveling to those countries on your foreign passport without the U.S. government's knowledge, this raises significant national security concerns. Second, the government is trying to identify people who are using dual citizenship to avoid tax obligations or to hide assets in foreign countries. The United States is one of the only countries in the world that taxes its citizens on their worldwide income, regardless of where they live. And dual citizens who maintain financial accounts and business interests in their other country of citizenship are seen as higher risk for tax evasion. Third, There are concerns about dual citizens who might be subject to military conscription or other mandatory service requirements in their other country of citizenship, which could create conflicts of interest or compromise their ability to serve U.S. national interests. The second significant change involves how dual citizens must declare their foreign citizenship when entering and exiting the United States. Under current key restrictions and requirements procedures, when you enter the U.S., you're required to present your U.S. passport if you're an American citizen, and immigration officers generally don't ask about other citizenships you might hold unless there's a specific reason to do so. Starting in January 2026, U.S. Customs and Border Protection is implementing enhanced screening procedures at all ports of entry that will specifically ask U.S. citizens whether they hold any other citizenships and which passports they used for their recent international travel. This information will be recorded in your travel history and cross-referenced against other government databases. If you enter the U.S. on your American passport, but CBP discovers through airline records or foreign government data sharing that you departed your last destination on a different country's passport, you'll be pulled aside for secondary inspection and questioned about why you're using multiple passports and whether you properly disclosed your dual citizenship status to the State Department. This enhanced entry and exit screening is particularly significant for dual citizens who routinely travel between the U.S. and their other country of citizenship. Many dual citizens have developed the habit of using their U.S. passport when dealing with American authorities and their foreign passport when dealing with authorities in their other country, which on the surface seems logical and has generally been tolerated. However, the new procedures are designed to create a complete picture of your travel patterns and inconsistencies between which passport you use where can trigger investigations. For instance, if you're a U.S.-Canadian dual citizen and you fly from Toronto to London using your Canadian passport, then from London to New York using your U.S. passport, CBP will now be able to see that you were in Canada and may question why you didn't use your U.S. passport for the entire journey. While being a dual citizen and using both passports isn't illegal, the government wants to understand the full scope of your international movements, and failure to provide truthful and complete answers during these screenings can result in your trusted traveler status being revoked, your passport being flagged for additional scrutiny on future travels, and in serious cases, investigations. Actions you must take immediately into whether you're using your dual citizenship for illegal purposes. The third major update involves tax reporting requirements for dual citizens, particularly those who hold citizenship in countries that don't have comprehensive tax information exchange agreements with the United States. The Foreign Account Tax Compliance Act, known as FATCA, already requires U.S. citizens to report foreign financial accounts exceeding certain thresholds. But enforcement has been inconsistent, and many dual citizens have avoided compliance either through ignorance or deliberate evasion. Starting in January 2026, the Internal Revenue Service is implementing automated data matching between passport records and tax returns. If you've disclosed dual citizenship on your passport application, but the IRS doesn't see corresponding foreign account reporting on your tax returns, you'll receive an automated notice requiring you to either confirm that you have no foreign accounts or to file amended returns, including the required foreign account disclosures. The penalties for failure to report foreign accounts are severe, ranging from $10,000 per year for non-willful violations up to the greater of $100,000 or 50% of the account balance for willful violations. This creates a particular problem for dual citizens who inherited their second citizenship through parents or grandparents and may not even be aware they're considered citizens of another country under that nation's laws. For example, many Americans of Italian, Irish, or Polish descent are actually citizens of those countries by ancestry, even if they've never applied for a passport or formally claimed that citizenship. If Italy, Ireland, or Poland shares information with the U.S. government indicating that you're a citizen based on their records, but you've never disclosed this on your U.S. passport application or tax returns, you could find yourself facing uncomfortable questions from federal authorities. The new procedures require you to be proactive in determining whether you hold citizenship in any other country under that country's laws, not just whether you've actively claimed or used that citizenship. The fourth significant risks of ignoring the law change affects dual citizens who are applying for security clearances, government employment, or contracts with federal agencies. Historically, holding dual citizenship hasn't been an automatic disqualification for security clearances, but it has been a factor that investigators consider when evaluating your loyalty and potential foreign influence. Starting in January 2026, the Defense Department and intelligence agencies are implementing much stricter policies regarding dual citizenship for anyone seeking access to classified information. The new guidelines create a strong presumption against granting security clearances to individuals who actively maintain and use foreign citizenship, particularly citizenship in countries that are considered strategic competitors or adversaries of the United States. This includes not just obvious countries like China and Russia, but also nations with complex relationships with the U.S., like Turkey, Venezuela, and some Middle Eastern countries. Under the new policy, if you hold dual citizenship and want to obtain or maintain a security clearance, you'll be required to take what's called mitigating action, which typically means formally renouncing your foreign citizenship and surrendering any foreign passports to U.S. authorities. Simply not using your foreign passport or claiming that your loyalty is solely to the United States is no longer sufficient. You must provide documentary proof that you've gone through the formal renunciation process with the foreign country, which can be complicated, expensive, and in some cases nearly impossible depending on that country's laws. Some countries don't allow their citizens to renounce citizenship at all, or they impose conditions like requiring you to complete military service before they'll accept your renunciation. This puts dual citizens in an impossible position where they must choose between maintaining their family heritage and cultural connections versus pursuing certain career opportunities in the U.S. government. The fifth major update involves how dual citizenship affects eligibility for certain immigration benefits for your family members. If you're a U.S. citizen who also holds citizenship in another country and you're petitioning to bring family members to the United States through family-based immigration, your dual how it impacts passports and benefits citizenship status can now affect the processing of those petitions. Starting in January 2026, USCIS is implementing enhanced vetting of family-based immigration petitions, where the U.S. citizen petitioner holds citizenship in a country that's on the State Department's list of state sponsors of terrorism or countries of concern for immigration fraud. If you hold dual citizenship with Iran, Syria, Sudan, or North Korea, your petitions for family members will face additional scrutiny and significantly longer processing times, potentially years longer than standard cases. The government's concern is that dual citizens from these countries might be using family immigration channels to bring individuals into the U.S. who pose security risks or who intend to engage in activities contrary to U.S. interests. The sixth change involves children born to dual citizen parents and how their citizenship status is documented and tracked. Under U.S. law, a child born in the United States automatically becomes a U.S. citizen regardless of the parent's citizenship status. And a child born abroad to at least one U.S. citizen parent generally acquires U.S. citizenship at birth if certain conditions are met. However, if that child also acquires citizenship in another country at birth, either through the other parent or through the laws of the country where they were born, the new January 2026 procedures require much more detailed documentation of the child's multiple citizenships when applying for a U.S. passport or consular report of birth abroad. Parents must now disclose all citizenships the child holds or is eligible to claim. Provide documentation from the foreign countries confirming the child's citizenship status, and in some cases provide written explanations of how they intend to handle the child's dual citizenship as the child grows up. This is particularly significant because some countries have mandatory military service requirements or other obligations for their citizens, and the U.S. government wants to know if American children with dual citizenship might be subject to these requirements. For example, if you're a U.S. citizen married frequently asked questions to an Israeli citizen, and your child is born with both U.S. and Israeli citizenship, Israeli law may eventually require your child to serve in the Israeli military when they reach 18. The U.S. government now wants this information documented so that if your child later applies for a security clearance or sensitive government position, there's a clear record of their potential foreign obligations. Some dual citizen parents are finding that this enhanced disclosure requirement feels intrusive and raises concerns about how the information will be used, but failure to provide complete and accurate information can result in passport applications being denied or delayed indefinitely. The seventh update affects naturalized U.S. citizens who retained their original citizenship when becoming American citizens. While the United States doesn't formally require people to renounce their previous citizenship when naturalizing, the oath of allegiance that you take during the naturalization ceremony includes language about renouncing allegiance to foreign states. For decades, this has been interpreted to mean renouncing political allegiance rather than formal citizenship, allowing naturalized Americans to maintain their original passport for travel and family purposes. However, starting in January 2026, USCIS is implementing new procedures to track whether naturalized citizens continue to actively use their foreign citizenship after naturalizing. This includes monitoring whether you renew your foreign passport, whether you vote in foreign elections, whether you serve in foreign military forces, and whether you accept employment with a foreign government. If USCIS determines that final tips and summary you're actively exercising rights of foreign citizenship in ways that appear inconsistent with your oath of allegiance, they may initiate denaturalization proceedings to revoke your U.S. citizenship. This is an extreme measure that's rarely used, but the government is signaling that they're taking a harder line on what they view as divided loyalties. Particularly concerning are cases where naturalized U.S. citizens have accepted government positions in their country of origin, which the U.S. government views as evidence that you haven't truly renounced allegiance to that foreign state. For example, if you naturalized as a U.S. citizen from South Korea, but then accepted an appointment as a cultural advisor to the Korean government. Even in an unpaid honorary capacity, this could potentially trigger a denaturalization investigation under the new policies. The eighth change involves how dual citizenship affects your ability to sponsor refugees or asylum seekers. If you're a U.S. citizen who holds citizenship in a country from which refugees and asylum seekers are fleeing, and you're trying to sponsor or support individuals seeking protection in the United States, your dual citizenship creates a conflict that will now be scrutinized more carefully. The concern is that dual citizens might be using refugee or asylum sponsorship as a way to bring individuals into the U.S. who aren't genuinely fleeing persecution, but are actually economic migrants, or who have connections to your foreign government. Starting in January 2026, sponsorship applications and asylum support letters from dual citizens will trigger enhanced background checks and potentially interviews to determine whether there are any improper relationships or motives behind the sponsorship. The ninth significant update involves reciprocal enforcement with foreign countries. The United States has been negotiating enhanced information sharing agreements with dozens of countries. And many of these agreements include reciprocal obligations, where the U.S. will notify foreign governments when their citizens naturalize as Americans, or when Americans acquire citizenship in those countries. This is significant because some countries have laws that automatically terminate your citizenship if you voluntarily acquire citizenship in another country. For example, if you're originally from China or India, both countries generally don't recognize dual citizenship. And if the U.S. shares information with those governments that you've naturalized as an American, you could find that your original citizenship has been automatically revoked under their laws, even if you still possess their passport. This can create complicated situations where you thought you were a dual citizen, but legally, you're only a U.S. citizen, and attempting to use your expired foreign citizenship could result in legal problems in that country. The 10th major change involves the intersection of dual citizenship with professional licensing and regulations. Many U.S. states and professional regulatory boards are implementing new requirements for licensed professionals to disclose their dual citizenship status, particularly for professions that involve access to sensitive information or critical infrastructure. This includes attorneys, healthcare providers, engineers, pilots, and financial professionals. Starting in January 2026, several states are requiring these professionals to report their dual citizenship status as part of their license renewal process. And in some cases, Holding citizenship in certain countries may result in additional oversight or restrictions on what types of work you can perform. For example, if you're a licensed engineer who holds dual citizenship with a country that's considered a strategic competitor, you may be prohibited from working on projects involving defense contracts or critical infrastructure, even if you have no security clearance. So, there you have it. A comprehensive breakdown of the important dual citizenship law updates taking effect in January 2026, from enhanced passport disclosure requirements to stricter security clearance policies, from new tax reporting obligations to changes affecting your family's immigration petitions. These updates touch virtually every aspect of how dual citizenship is regulated and monitored in the United States. The most critical action you can take right now is to ensure that you've properly disclosed all of your citizenships on every relevant government form, that you understand the tax reporting obligations for foreign accounts, and that you're prepared to provide detailed information about your dual citizenship status whenever dealing with U.S. authorities. If you found this information valuable, please subscribe to U.S. Visa Information for ongoing coverage of immigration law changes, citizenship regulations, and visa updates that affect millions of people in the United States. Hit that notification bell so you're immediately informed when new policies are announced or enforcement procedures change. And if you have specific questions about how these dual citizenship updates apply to your personal situation, leave a comment below, and I'll do my best to point you toward appropriate legal resources. Remember, when it comes to citizenship and immigration matters, ignorance of new requirements is not a defense, and being proactive about compliance is always better than facing enforcement actions later. Thanks for watching U.S. Visa Information, and I'll see you in the next update where we'll continue keeping you informed about the immigration and citizenship laws that affect your life in America.